If you've ever made a big decision because of something your employer promised you, and that promise was broken, you may have experienced something called detrimental reliance. In this video, I'll explain what that means and how it works in employment law, and when you might have a valid legal claim. Hi, I'm Tom Spiggle, founder of the Spiggle Law Firm, where we help people who've been fired or afraid that they might be. So what is detrimental reliance? It's a legal concept that comes from something called promissory estoppel. Here's the simple version. If your employer makes a promise and you make a big decision based on that promise, like turning down another job or moving for work, and you end up getting hurt financially because of the promise wasn't kept, you may be able to take legal action, even if you didn't sign a contract. To win a detrimental reliance claim, you generally have to prove four things. First, the employer made a clear and specific promise. Second, you relied on that promise. Third, your reliance was reasonable. And fourth, you suffered a real loss or harm as a result. Let's look at an example. Imagine an employer tells a job candidate, "We're offering you a full-time position. If you move here, you'll have a job starting August 1. The candidate accepts, sells their house, moves the family across the country, and then, right before August 1, the employer rescinds the offer with no explanation. In this case, the candidate may have a valid detrimental reliance claim. Why? Because the promise was clear. You have the job. The person relied on it. They moved. The reliance was reasonable. And they suffered harm, selling their house, relocating costs, possibly being unemployed. Now, let's look at a situation where the employee likely wouldn't have a valid claim. Suppose an employer says, "We're thinking about promoting you sometime next year if things go well." The employee turns down another job offer based on that statement. Here, a detrimental reliance claim probably wouldn't succeed because the promise wasn't definite or specific. It was more like a hope or a possibility. And relying on vague language like maybe or someday isn't considered reasonable in court. If you're thinking about filing a detrimental reliance claim, here are a few things to keep in mind. Courts look at how specific the promise was. The more detailed and concrete, the better. You'll need to document everything, emails, text, anything that shows what you were promised and how you acted on it. These claims often come up in job offers, relocation promises, or offers of continued employment after layoffs. It's also important to act quickly. Employment claims often have strict deadlines, depending on your state and the facts of your case. So, what does this mean for employees? If you made a major life decision based on a promise from your employer, and that promise was broken in a way that caused you real harm, you might have legal options. But these cases are tricky and fact-specific. That's why it's important to talk to an employment attorney early. We can help you figure out whether you have a claim and what steps to take next. Thanks for watching. If you have questions or think you've been misled by an employer's promise, reach out to us at the Spiggle Law Firm. We're here to help you take back control of your career.